got an RNO that he was on probation for in circuit. It's like, who doesn't have an RNO? And then he's on probation for that, picks up this, and I could see having but having him on a home confinement, I don't understand why we're confining him to his house.
And that's why I would ask this court to change that, Your Honor.
That was a rhetorical question. Does he have a failure to appear at all?
No, Your Honor, nothing.
He's set to come back and see me at 7. So I'm going to order it this time. I'm going to grant the motion. I'm going to order the tether be removed. I dare you not to show up.
At this time, Your Honor, we'll be asking for brief adjournment. I provide some documentation yesterday that APA showed us to consider for a resolution in this matter, and Ms. Coed intends to provide me some more tomorrow.
April 16, 2026, 9 a.m.
Thank you so much, Your Honor.
Bond continued. Thank you, Ms. Collette.
Thank you, Your Honor. Have a nice day.
You too. Court does call the case People versus Robert Jovashevsky.
On behalf of the people, Your Honor.
Assistant Public Defender Shanazi Karyat on behalf of Mr. Jovashevsky.
Shevsky. You don't know.
I don't.
Yeah. Your client.
Yeah.
How come I know and you don't?
Bad with names.
Sir, keep clicking ahead.
I'm sorry, Your Honor.
State your name.
Robershevsky Robert.
Now we'd be asking for an adjournment today. We would be submitting a competency evaluation.
You're going to be requesting a forensic.
That's correct, Your Honor.
Probable cause conference will be adjourned April 9th, 2026 next. On continue.
We request that to be done in person, ma'am.
Say that.
Can we request that the competency exam be done in person and not over the video?
I can talk with them and see.
Would you please, because I can't hear and it presents a big issue. Okay. And I don't want to be uncooperative.
Okay.
All right.
Did you want me just to order A, or did you?
I have the report.
Or you have the? Do you have the form?
I
can order it today if you
Perfect.
want.
Okay.
Okay.
Yep. I'll
I won't have to print it out. A forensic evaluation will be ordered. I'll set a competency hearing for June 25th, 2026, 9 a.m. We can move that date up if we get a report for then.
Okay.
Okay, Bob, we'll continue.
Your Honor, I apologize for my behavior to you, sir.
Not a problem. Take care of yourself.
Oh, gosh.
Keep moving. Keep moving. Why do you do that? What? What? I can really, if you're not going to have your clients under control, we're going to have a problem.
Put a spell on them.
I just checked.
Spell on him? Good? You did good. I don't think you did, but guess if Alan says, whatever. Court does call the case of the People versus Maurice Edy.
I'll check loud to the people, Your Honor.
Brian Mulligan on behalf of Mr. Edy, Your Honor. Maurice, state your name for the record, please.
Maurice Edy. Thank you. I have before me a plea form that indicates that the defendant would be pleading guilty to an added count 2 of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the.
Yes, sir.
That's my understanding. Well, Judge, is that your understanding, Mr. Edy?
Yes, sir. Let's have him sworn.
Right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Help you God.
I do.
Thank you, please.
Maurice Edy. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Do you understand?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Signed an advice of rights form, is that correct?
Yes, sir.
Question regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will.
Sir.
And because you believe that you're guilty of this offense?
Yes, sir.
On the date of May 13th, 2025, at the location of 1020 Whitaker Road in Ypsilanti Township, Washington County, State of Michigan, were you in possession of cocaine?
Yes, sir.
Used it?
Yes, sir.
Know what you were using was cocaine?
Yes, sir.
Sir, if I accept your plea, between the time I accept your plea and the time of sentencing, you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Okay.
I'm not.
And have I complied with the court rule?
You have.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
May 7th at 10 a.m.
said May 7th.
Yes.
May 7th, 2026, 10 a.m. That's before Judge Washington. Bond will continue. All right.
Thank you, sir.
Thanks, Judge.
Court calls the case People versus Donovan. Is it Dragowski? Dragowski?
Alex Jablowski, the people, Your Honor.
Brian Bowling on behalf of Mr.
Ron
Rognowski.
Dragowski. Yeah. I don't know. Ask Chanaz.
Rognowski. Donovan, just state your name for the record, please.
Donovan Drungowski.
Dragowski.
Your Honor, I'm asking this matter be set for a preliminary examination, please. I believe all discovery to be complete.
People have their witnesses available on the 7th. Set preliminary examination for April 7th, 2026, 9 a.m. before Judge for me. All right.
Thank you, Your Honor.
On continue. Thank you.
Yep.
Court calls the case People versus Braddock. Braddock.
Stephanie Cannon on behalf of Derek Braddock, who should be appearing by Zoom, Your Honor.
I'm here.
Okay, state your name.
My name is Derica Braddock.
All right.
Your Honor, the Attorney General and I are in negotiations regarding this matter. We are just asking for an adjournment. I believe a green sheet has been submitted.
No objection.
How much time are you guys gonna?
Your Honor, the discovery in this matter was voluminous. Yes, you know this. So, Your Honor, I believe, and she's asked that we mail her a copy. She lives on the West Coast, so I'm of Michigan, so I am going to mail her a copy of that. So 2 to 3 weeks, Your Honor.
When I go to the 23rd. You can mail it. Proper cause conference will be adjourned April 23rd, 2006, 9 a.m. Bond.
Thank you so much, Your Honor.
Okay,
All right. Thank you, ma'am.
thank you.
Court calls the case People versus Cedric Green.
Your Honor, Raymond Cook for the people.
3 case.
Assistant Public Defender Jay Ballinger on behalf of Cedric Green, who will be approaching shortly, I imagine. Your Honor, I'm not sure if I turned in a green sheet, but we will be setting today.
You'll do what?
I think I may have turned in a green sheet for that. We'll be setting today.
Really? On all 3? So we're gonna need this.
Mr. Green, will you please name for records? State that a little louder for the court.
Cedric Green.
All right.
There's none yet. He told me I should talk to them over the next week or so via email so I can see about getting one. Your Honor, with regard to these cases, we are going to be asking to set all three matters for preliminary exam at this time. In the interim, for my client's sake, and for the record, I will be working with Mr. Cook as well as Mr. Vangallo in the circuit court to attempt to get him some sort of offer going up.
Got it. All right. Discovery is complete on these cases.
To the best of my knowledge, Your Honor.
Are other witnesses available the 7th?
Your best, Your Honor.
Preliminary examination in these cases will be set for April 7th, 2026, 9 a.m. before Judge Perry.
And then, Your Honor, as to the bond violation, I have had an opportunity to discuss that with my client.
Go ahead.
I'm working on that right now. With regard to the violation, Your Honor, it's my understanding that my client would be admitting to the violation. However, somewhat of an explanation here, and I would be asking to address bond.
I don't have my copy of it. Oh, there it is. Okay. Yes, go ahead.
With regard to an explanation, Your Honor, my client reports that his bag was stolen from him. He had no way to charge his devices. The charger was in that bag. My understanding is that the device was then cut from his leg. I don't know that my client would admit to doing that himself or that someone else did that on his behalf. However, like I stated,
What? So this is part of the explanation?
this is part of the explanation, Your Honor.
Grab his leg and cut it off? Okay. Go ahead.
He was, Your Honor, he advises that he advises that he was scared at the time, that he wasn't in his right frame of mind, and that he wasn't also on his medications. And he advises that he was getting high, Your Honor.
Get what?
Getting high, Your Honor. And in that regard, like I stated, Your Honor, I would ask to address bond.
Motion for bond reduction is denied. Defendant admitting to the violation. I will sentence him on a state of the violation. On the violation, I'll sentence him to 7 days, credit 7 days, sir.
And Your Honor, would the court be willing to consider a release to an inpatient treatment or
Send the order. Oh, I don't think there'll be a problem, is there?
Your Honor, for the record, the people would have an objection to that, given that he was cutting off his tether. I have concerns that release to treatment, even with the tether order, that would not be sufficient.
But if he's treatment, he's probably not getting high, which is probably part of the reason that the ghost came up and cut his tether off.
I'm not an expert on ghosts, so I can't say that, but
It was scared or something. I will sign an order.
Okay, thank you very much. Yes, yes. I will get the order in today.
The violation was only on, so they just have to do like the normal. Yes. Court does call the case, People versus Wesley Edwards.
Hannah Mackey on behalf of, Hannah Mackey, mission practice under Michigan Court Rule 8.120, under Public Defender Joy Gaines.
Who?
Hmm.
Which one are you practicing under? You're looking for one that you like?
Miss Joy Gaines, right?
Oh, Miss Joy Gaines. Okay. All right. Permission to practice is granted.
Thank you, Your Honor.
Sir Edwards, can you state your name, please?
Hi, my name is Wesley Edwards Jr.
All right. I have before me a plea form that indicates that he's going to be pleading to an added count 3 of attempted possession of a loaded firearm in a motor vehicle, the 1-year offense. On a successful plea to that charge, counts 1 and 2 would be dismissed. There is also a sentence agreement to hideout. That's the court's full understanding of the agreement.
That is correct.
Mr. Edwards, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Name again.
My name is Wesley Edwards Jr.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor, punishable by up to 1 year incarceration, a $1,250 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that, sir?
Yes, sir.
All right. You also understand, sir, well, the box isn't checked, that while I'm taking your plea, I would not be your sentencing judge, and you'd be sentenced before Judge Washington in the 14B District Court.
Yes, sir. Can I question that or no?
Can you question what?
I was just questioning, like, does that mean so the whole probation thing, you don't sentence that would handle in 14B?
Yes.
Okay,
The whole height of everything, all of the sentencing aspect would be handled in 14B by Judge Washington.
Okay, no, that's all. I just wanted to understand.
Okay. All right. So understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form. Is that correct?
Yes, sir.
Any questions regarding those rights?
No, I would have those questions would all be for the PL, so no.
Okay. And you understand that you're waiving or giving up all the rights that are contained on that form?
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are indeed guilty of this offense?
Yes, sir.
March 7, 2025, at the location of Rawsonville near I-94, Ypsilanti Township, Washington County, State of Michigan. Were you in a motor vehicle?
Yes, sir.
Did you have a firearm?
Yes, sir.
And where was the firearm located?
Like right next to me in my backpack.
Right next to you?
Yeah,
Was it
in my
loaded?
backpack.
Was it loaded?
Yes, sir. Everything was with it in the case. Yes.
All right. You don't have the authority to carry a weapon in that fashion, do you?
In my state, I do. I just didn't know in your state we don't. So that's on me.
What's your state?
Ohio.
Sorry to hear that. But here, you don't have the authority to carry that, right?
Yes, sir.
Sir, if I accept your plea, you need to understand that between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, first of all, you would not be entitled to withdraw your plea, and the judge would not be bound by any further or any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Have Your Honor.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
7th at 10 a.m.
May 7th, 2026, 10 a.m.
You said May?
May 7th.
Okay. We can't. Is there any earlier or no?
You can talk to her court or you can have me sentence you today, but I don't think you want me to do it.
All right, never
Mr.
mind.
Adams, I'll be in touch with you.
Okay,
That's
let's go with the date. Bond continued. Thank you.
Your Honor.
Nobody. Court does call the case of the people versus Thomas Kumasca.
Oh, I'm sorry. On behalf of my client, who should be coming out of custody.
Can I pause this?
Well,
Can we pause this?
we set those for exam.
Yeah, sure.
Yeah.
So, please state your name for the record, sir.
Thomas Kumasca.
Thank you, Judge. I have been in contact with Mr. Childers. I believe we have reached a resolution. The paperwork is not filed, however. If we could ask for just a 1-week adjournment, we would have this matter ready to be played out, Your Honor.
April 2nd, 2026, 9 a.m. Bond continued.
All right, that's
Thank you. Court calls the case, People versus Raan Ellis.
Hannah Mackey on behalf of Mr. Ellis, who is approaching, Your Honor. Your name?
Raan Ellis. Raan Ellis.
Thank you. All right, what are we doing?
Your Honor, we'd like to set this matter for exam,
Discovery is complete.
as far as we are aware.
People have their witnesses available the 7th.
Do our best.
Preliminary examination will be set in person, April 7th, 2026, 9 a.m. before me. But bond will continue.
Your Honor, may I just bond?
Doubt.
Is a bond condition.
Oh, there you go.
Mr. Ellis is currently on a GPS tether for home confinement, actually, not GPS. And we asked this court if that tether could be removed. He has to go to work. He is allowed to go to work, but also he has to take care of his younger siblings. His mom works 2 jobs, so it's hard for him to get around and do all that.
What else does he have? Because
Also,
normally in a case like this one, he wouldn't be put on home confinement. Pardon?
He also has a curfew as one of his conditions. Oh, what other cases? He has an R&O in circuit court, Your Honor.
Your response from the people.
Thank you, Your Honor. Your Honor, we were initially asked for a 30,000 in this case. Due to the fact that he was on currently on probation circuit court. This is where he admitted to possessing a pistol while he's on probation, so he felt that safety of the community was paramount, and we would ask that bond be continued with this current condition.
And Your Honor,
Got an R&O that he was on probation for in circuit. It's like, who doesn't have an R&O? And then he's on probation for that, picks up this, and I could see having on but having him on a home confinement, I don't understand why we're confining him to his house.
and that's why I would ask this court to change that, Your Honor.
That was a rhetorical question. Does he have a failure to appear at all?
No, Your Honor, nothing.
He's set to come back and see me on the 7th. So I'm going to order it this time. I'm going to grant the motion. I'm going to order the tether be removed. I dare you not to show up.
Well, so
Hear me?
yes.
Because then we won't need a tether because you'll be back there.
Yes, sir.
Am I clear?
Yes, sir.
Thank you.
Thank you so much, Your Honor.
Court calls the case, People versus Reese Palmer.
For the people.
Okay.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Palmer.
What's your name for me?
My name is Reese Palmer.
All right. I have before me two plea forms indicating that Mr. Palmer is going to plead guilty to two charges of retail fraud, second degree, the 1-year offense.
That is correct.
Right? Okay. Those are, well, on the one case, 123-1072, that's, I think, the stated count.
That's
right? He brought that one in.
That is.
And on the other case, that's an added count 2 with count 1 being dismissed. There is an understanding that, and there's no other understanding. That's the court's full understanding of the agreement. I'm satisfied.
That's correct, Your Honor.
Is that correct, Ms. Gaines?
Yes, Your Honor.
All right. Can I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Reese Palmer.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to 2 charges of retail fraud. Is that correct?
Yes.
All right. Now, those are misdemeanors punishable by up to 1 year incarceration, $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that becomes your maximum fine. You understand that?
Yes, sir.
All right. Still wish to plead guilty to those charges?
Yes, I do, sir.
All right. Starting in the case ending in 1960 to an offense occurring on August 31st, 2025. To that charge, how do you plead?
Guilty.
All right. To that same charge contained in the case ending 1072, occurring on June 28, 2023. All right. Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, I did.
You have any questions regarding any of those rights?
No.
All right. Look at copy on the podium. Look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No probation, no parole. I haven't had a ticket or nothing in 8 years, sir. These cases is 2 or 3 years old. I was in a bad place, sir. I was homeless, but now I'm in a better place. I just want to get this behind me, sir, and get back home.
All right. We'll work on that, okay? All right. Has anybody promised you anything other than what's been stated today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
And because you believe that you're guilty of these offenses?
Yes, sir.
Okay, starting with the case ending in 1960. On the date of August 31st, 2025, at the location of 3825 Carpenter Road, that being the Meyer store, what'd you do on that date that makes you think that you're guilty?
I took a bunch of shirts, sir. I was homeless and I needed clothes.
And you tried to walk out without paying for them?
Yes, I did.
And these items you took, Meyer had offered for sale?
Yes, they did.
And you didn't have anybody's permission to take that, did you?
No, I did.
On the other case, on the date of June 28, 2023, again at the Meyer store at 3825 Carpenter Road in Pittsfield Township. What happened on that day?
I took some liquor, sir, because I was staying in the tent. I need to get warm. So I took a couple bottles of liquor.
Okay. And I think this one is actually on a prior offense. Had you previously been convicted in 2018 of a retail fraud? You recall that?
I don't know, sir. I was in a...
Let me ask it this way. you previous to 2000, you had been convicted of retail fraud before that, right?
Yes.
Okay. All right. Mr. Peterson, if I accept your plea, and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your pleas. You understand that, sir?
I understand that, sir.
Okay. And the court would not be bound by any sentence evaluation or recommendation. You understand that?
I understand that, sir.
All right. Counsel, have there been any other promises, threats, or other indications which have led to this?
None from the people?
No, thank you, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, sir.
I will, in the case ending in 1960, I will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be April 8th, 2020 for me. And
May we address bond, please, Your Honor?
one moment. And on the other case, I'm also going to refer him to probation for a pre-sentence investigation and report. Sentencing will be April 8th, 2026, 9 a.m.
Street.
Yes, that's about. Where's he? Christian, where are you living now?
I'm on Ecorse Road, 111 Ecorse Road in Ypsilanti,
It's not
Michigan.
his paperwork that we submitted, his address,
Yeah, no, I got it.
but he
Oh,
has his own
It's township.
place.
Yes, I have a place, sir. And I'm in a good place now, sir. I'm just trying to move on with my life. And like I said, I didn't know these cases was behind me. I would have had them taken care of before I came, before this even got to this matter.
Okay, and
He's receiving Social Security now, Your Honor.
I'm aware of Mr. Peterson's bid. And so, Mr. Peterson, let me ask you, if I let you out, you're gonna make sure to get over to my probation department?
Yes, I will, sir. I'll be there.
And you're gonna get, because both of these cases are before me.
Yes, sir.
Gonna get yourself back here?
I'll be back here, sir. On court date, I'll be here.
Hold on. Is your balance okay?
Any response to the bond modification in the future?
No, Your Honor.
I'll grant the motion. Mr. Peterson, I'm gonna let you go home.
Thanks,
Right.
sir.
I'm gonna set your bond in each of these cases at a personal recognizance, $5,000. And I'm ordering you don't go into any Meijer store in the state of Michigan. You hear me?
No, sir.
All right.
Thank you.
Thank you, Your Honor.
That it?
Yeah.
I see you, Mr. Gardner.
Yeah. Take his phone. You let him keep the phone? He turned it off. He didn't know how to turn it off. That's why he ran all the way out.
I am deeply sorry, Your Honor.
And you let him keep it? He's good?
I did not have to resort to finding a hammer to smash my phone.
That's what I was gonna do. That's why I want to know. But you let him have it.
Got a headache. I was very sorry, and apparently I moved very quickly.
Oh, you were moving. I didn't know Levo could move that fast. He was trying to get out. Court next case. Levo versus Avon Johnson.
Children's appearing on behalf of people.
Edward Rodriguez on behalf of Avon Johnson.
Johnson, can you state your name?
Avon Johnson. Afternoon.
Are we doing the plea form?
We are, Your Honor.
Okay, I have a plea form before me. Indicates he's going to be pleading to count 2, an added count 2 of reckless use of a firearm, 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. How long has he been in there?
Quite a while. He gets out in May. May. I didn't check the box to sentencing judge waiver. I don't know if
Because you were looking for me to do something.
I was seeing if he sentence him today. If not, we can go over and see Joseph Washington.
Is that the court's full understanding of the agreement?
Yes, Your Honor.
Is that the understanding? All right. Sir, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
State your name again.
Avon Johnson.
All right, sir, it is this court's understanding that you're going to plead to the charge of reckless use of a firearm. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
To that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Right. You gave permission to have an advice of rights signed on your behalf. Is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
All right. You understand that you're waiving, giving up all of the rights contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
All right. And because you believe that you're guilty of this offense?
Yes, Your Honor.
October 30th, 2023, at the location of 1120 Wood Glen Avenue, Ypsilanti Township, Washtenaw County, State of Michigan. Did you have a firearm in your possession?
Yes, Your Honor.
Did you fire it?
Yes, Your Honor.
Would you admit that when you fired it, you did so in a reckless fashion?
Yes, Your Honor.
All right. Sir, if I accept your plea, well, I'm not going to go through that. Counsel, are you aware of any other promises, threats, or other inducements which are led to the plea?
No, Your Honor.
Have I complied with the
Defense is satisfied.
court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Anything you want to say before I impose sentence?
No, Your Honor.
No.
Mr. Johnson, how long you been in Oakland?
15 months.
You've been in 15 months?
Yes, Your Honor.
Sorry.
I'll sentence him to $125, which is state minimums. I'll sentence him also to 90 days in jail. Credit 90, sir. All right. You're all set with us, Mr. Johnson. Take care of yourself.
Thank you, Your Honor. Here's what.
Court calls the case People versus Thomas Vasher.
Then on behalf of the people, you're.
Judge,
5 cases.
court shall feast the first public defender on behalf of Mr. Vasher, who should come.
Is it 5?
Oh, it is. I have 4.
Didn't I have 4 cases. Did I say 5?
Yes, Judge.
Okay, I lost count.
No problem.
Maybe.
Please state your name for the
Correct.
record, sir.
Thomas Vasher.
Thank you.
Thank you,
Yes.
Judge. We're requesting adjournment in this matter. Ms. Zinda did turn over some phone calls, I believe, from the last court hearing that I need to play for Mr. Vasher. He does want me to seek a release to inpatient treatment to Dawn Farms in jail and have the court sign an order so he can prioritize and get in as soon as possible.
Okay, for release on probation.
Correct. I'm sorry.
All right.
Yeah, he's not gonna do.
Are the people going to have any objection to release to inpatient?
I would have concerns given the calls in jail to the victim on the DB case that he has.
The Dawn Farms in jail, inpatient treatment.
Oh, you want me to order the in?
Yes, Judge.
You submit an order. No,
Thank you, Judge.
I'll sign off on it.
That's all.
Okay. I thought you were asking for him to be released.
No, Judge.
Okay. Yeah, that's not a
All
problem.
right, thank you, Judge. Just a couple weeks, please, and I'll go through the phone calls with Mr. Vasher and try and get this resolved.
Want the 9th or the 16th? How many?
9th is fine.
Sure.
The 9th or the 16th.
We do the 16th, Your Honor.
Because she's not.
Yes, please, Judge.
Probable cause conference will be adjourned April 16th, 2026, 9 a.m. Bond continue. Thank you.
Shit.
I know.
Since it's fine, go to Dennis.
Just went to court on that.
I'll show you the paperwork I got. So I just went paperwork. Go to Dennis, I'll show you. Thank you, Judge.
There are more conversations going on today. Tonight on Easter.
Apologies.
Court calls the case. People versus Amber Estelle.
Assistant Public Defender Jay Bellinger on behalf of Miss Estelle, who should be an appearance via Zoom, Your Honor.
So, can you state your name, please?
Amber Estelle?
Estelle. I apologize, Miss Estelle. Your
that's
Honor.
fine.
Told me to pronounce it that way.
Your Honor, I am seeking another adjournment on this matter. We are still awaiting some information regarding her Kate Hill sale. I think our goal here is to see about treatment court to transfer over to Hillsdale.
Right. That's what I remember.
In order to do that, we just need to continue on with that case.
All right. So how much more time do you think?
I think I would be asking for about 3 weeks right now. Miss Estelle, your next court date over there is on, did you say it was April 13th?
Yes, sir.
So I don't know how far the court would.
April 13th.
April 13th is their next court date there.
So let's do this then. Is that case that she has the next court date, that's the case that would be going over to sobriety court, or?
I believe, yes, that is my understanding. And then we would see about.
Try to see if you can got it.
Exactly.
Okay. So here's what I'll do. I'll adjourn this out to April 30th, 2026, 9 a.m. We'll just give you a month, see if that could work out there and.
Thank you very much.
What we can do. Okay.
Appreciate it.
Bond will continue.
Miss Estelle, we'll be in touch.
All right. Thank you so much. Have a great day.
You too. Court calls the case People versus Lawrence Fenderson.
I'll check out the people you're on.
Assistant Public Defender Jay Bellinger on behalf of Mr. Fenderson, who should also be an appearance via Zoom.
What did you say?
She said.
Where? Not here.
Fenderson, it's not on Zoom.
No.
Okay. Well, we have had contact with Mr. Fenderson, Your Honor, as of yesterday. So I am surprised.
As of yesterday?
As of yesterday, I'm surprised he's not here this. I had my fellow talk to him, Your Honor.
Think he upset him? No.
I would hope not. Oh, people can be. I would ask for an adjournment, Your Honor, a brief one. If we can get sometime next week, that'd be great. Way I can sure that he's here. Then if I have to do it myself.
Defendant's failure to appear. Bond will be at a $10,000 cash surety. However, given the circumstances, won't issue that warrant until Friday.
Thank you. Thank you very much.
Court calls case of people versus Kyle Zimmer.
Alex, check well.
Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Permission to practice is
Thank you. Can you state your name for the record, please?
Kyle Zimmer. Thank you. Requesting an adjournment.
Yeah.
Okay. Will 2 weeks be enough for you, or you need 3?
2 weeks should be good.
Probable cause conference, April 9th, 2026, 9 a.m. Bound continue. All right, thank you, sir.
Thank you.
Court calls case of the people versus Daryl Gardner. Oh, yeah.
When you're on agreement to cook the people.
They're, hold it. They're in, aren't they? It's not Gardner. The court calls case people versus Tiana Freeman.
And imagine on behalf of
Yes.
Mrs. Freeman.
Oh, I'm here.
State your name, ma'am.
Tiana Freeman.
All right. You need to be someplace where you're stationary. I have a plea form in front of me that indicates that the defendant is going to be pleading guilty to 2 charges. The stated count 2 of operating while intoxicated, second offense. That's a 1-year offense. And then also to count 3, which is carrying a weapon under the influence. Is that the stated count 3?
I think it's the stated now.
Gotcha. All right. Upon her successful plea to those 2 charges, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct?
That is correct, Your Honor.
All right. Ma'am, can you please raise your right hand?
Yes.
Solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name again, please.
Tiana Freeman.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor counts. The first is count 2, which is operating while under the influence, second offense. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. And also that you'll be pleading to the stated count 3 of carrying a weapon under the influence. That is a misdemeanor, punishable by up to 93 days in jail, a $100 fine plus court costs. If the weapon or you have a CPL, the county clerk would be directed to revoke that license to carry a weapon. You understand that?
Yes, sir.
All right. I also have to advise you, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Do you understand that?
Yes, sir.
Do you still wish to plead guilty to these charges?
Yes, sir.
To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of carrying a weapon under the influence, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed or had cause to be signed on your behalf and advice of rights?
Yes, sir.
You have any question regarding those rights?
Not at the moment.
All right. You understand that you're waiving or giving up all of those rights?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
You on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of these offenses?
Yes, correct.
On August 30th, 2025, at the location of South Huron River Drive near Harvard Cove Court, Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, sir.
What'd you have and how much?
I'm not sure about how much, but I was drinking some Patron at a gathering, so I did have a few shots of alcoholic beverages.
All right. Were you stopped by the police or was there an accident?
There was an accident.
What happened?
I crashed my motor vehicle, and the police were called.
All right. Police arrived at the scene. Were you arrested?
Correct. Yes.
Were you taken to the hospital for a blood draw?
Yes.
And what were the results of that blood draw?
I'm not sure of the exact numbers, but I was well over the limit.
It would stipulate to 0.161.
All right. The 161, do you have any reason whatsoever to dispute those blood test results, man?
No, not at the time.
Not, well, I'm going to ask that again. Do you have any
No.
reason to dispute those blood test results?
No, sir.
All right. And had you previously been convicted of operating while impaired on or about February 17th, 2022 in the 34th District Court?
Yes, sir.
All right. And on back to the date of the August 30th, did you have a weapon in your possession?
Yes, sir.
What was it?
A 9mm pistol
And where was it located?
inside of my vehicle.
All right. Inside the vehicle that you crashed while intoxicated?
Correct.
All right. Ma'am, if I accept your plea, I do have to advise you between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And has the court complied with the court rule?
Have, Your Honor.
Court will accept the defendant's plea to guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and screening assessment is ordered at 14B District Court. Sentencing in this matter will be
10 a.m.
May 7th, 2026, 10 a.m. before Judge Washington.
Okay.
Bond will continue.
Honor.
Thank you, ma'am.
Ms. Freeman, I'll
Thank
be in
you.
touch.
Okay, thank you.
Court calls case People versus Daryl Gardner.
Your Honor, ring.
Morning, I'm Rep. J. calling back, Mr. Gardner. He's being brought out. Judge, it's a change of plans. I'm not going to be asking for an adjournment. I'm going to go to exam.
On both.
That's Mr. Gardner's request. I think I can discovery beforehand.
You don't have the.
There's a video, but Judge, I think I can, if I get a couple weeks, I know I can get it. In fairness to him, that's what he'd like to do. Mr. Gardner, state your name.
Daryl Gardner.
Judge, just for the record, I was just recently appointed. I've finally had a chance to speak with Mr. Gardner. I understand his impatience with this matter. He'd like to go to exam. I'm 99% sure I can get the video that we need to get prior to the exam. So we're asking to go to exam.
And Your Honor, I do see that on the unarmed robbery case, there's a meeting notice that was marked and previously sent to the public defender. That one will be okay quickly. I see we received media just yesterday on the malicious destruction case. I'll get that marked and hopefully sent today. The issue is that I don't believe we have Mr. Killwell's appearance on file yet for that malicious destruction case.
So far, I'm not sure I've been appointed to that, but we'll see.
He's the set, Mr. Levo's assigned this one.
On the MDO.
Yeah, I called all of his cases.
Selectman Davi Leva from Gardner on the MDOP matter.
Okay, well, what are we doing on your case?
We're requesting adjournment in order to receive discovery.
To get discovery on that one?
Yes, Your Honor.
All right. And on the case ending in 032, I'll adjourn the probable cause conference to the 9th, April 9th, 2026, 9 a.m. On the matter will continue. You want to proceed that quickly to exam on the other one? You don't have all the discovery.
I
have the paper discovery.
I've got some of it. Judge, I will get it.
I know that, but if you don't have it, Mr. Gardner, you understand that that's not going to be the basis for an adjournment, and you'll just be without the stuff. I don't understand what
the judge is saying. If we set a preliminary exam and I don't get all the discovery, including the video, which you want to watch, the judge is still going to go to exam that day, even though we don't have it. That's the risk we take. I think I can get that, but you have to know that if you still want to go to exam. Is that your wish?
I mean, I want what's in the best interest of me being just. I want justice, man. The video is justice.
Okay, that's okay. Let's set the exam date, and I will ensure that.
Well, he's going to need to.
Judge, I'm not trying to be difficult. I'm sure
you are. I mean, because you know what I do, and I'm trying to. He wants to make sure that he's got the exam. I'm just trying to make sure that he's going to have the discovery and what he wants. That's what I want, Your Honor. And that he wants to see it. That's my issue.
Right.
I'm just trying to let him know if you get to exam and you don't have it or haven't been able to watch it, you're not going to get an adjournment for that purpose. I'd rather wait. I'd rather wait and further discover.
Okay.
Probable cause conference will be adjourned to the 9th. Same time as your other one, sir. April 9th, 2026, 9 a.m. Bonds, let's get your other one.
have a second, Arjun. We're coming back. I will see you this weekend.
Don't have it yet, but I got it.
You see, I can do that.
Yes, I got one right in the pocket.
Don't have
They have 4 people already.
those.
Correct.
Penalties.
Court calls the case, people versus Corey Faulk.
Assistant Public Defender J. Ballinger on behalf of Mr. Faulk, who does appear via Zoom, Your Honor.
Sir, state your name.
Corey Faulk.
All right, what are we doing?
Your Honor, I am asking for a bit of an adjournment here. I did just submit Mr. Faulk for mitigation through our AIM division.
Got it. Probable cause conference, April 16th. Think that'd be enough time for.
What I can say, Your Honor, is that it's my understanding that this will be assigned to someone from our AIM division on the 30th.
Let's go to the 23rd.
Thank you.
2026, 9 a.m.
Appreciate it.
Bond will continue. All right. Thank you, sir.
Thank you, Your Honor.
Court calls the case, People versus Allen Fife.
Brian Bowling on behalf of Mike, Your Honor. Hey, Alan, can you state your name for the record, please?
Alan Fife. Morning, Your Honor.
Morning, sir.
Judge, I'm asking for an adjournment. It's my understanding that Ron Brown in my office sent some materials to Burton Harris in the prosecutor's office, mitigation materials. So we're looking for a resolution. We're still working on it.
April 16, 2026, 9 a.m. All right. Thank you, Mr. Fife.
Thank you, Your Honor.
Thanks, Judge.
Court calls the case People versus Sincere Godwin.
Okay, well,
Ready, Judge. Portia Feaster, Assistant Public Defender on behalf of Mr. Sincere Godwin. He is not here, Your Honor. My understanding, and speaking to Attorney Kariak and Ruley, is that she had him up yesterday. She had him.
That's gonna be the best evidence she got. Go ahead.
Thank you, Judge. She had Mr. Godwin up yesterday at Circuit Court. They did a violent check, and he apparently is in jail in Wayne County, Your Honor. And so that's my understanding. He is currently incarcerated, and we'd be asking for an adjournment based on his incarceration.
That's what she's called.
She's an officer of the court, Judge.
Okay.
At her word.
Benchmark will issue bond 10,000. Cash surety case. The warrant will issue immediately.
Thank you, Judge.
You're welcome. Next time, at least say like Bellinger from somebody. No.
Yeah.
I'm just kidding. Wow.
I'm just kidding.
Court calls the case People versus Aria Griffin Bills.
Morning, Your Honor, Raymond Cook, the people.
And Assistant Public Defender Jay Bellinger on behalf of Griffin Bills. Griffin Bills, can you please state your name?
Aria Griffin.
What are we taking the plea?
We are doing the plea today, Your Honor. I would ask to voir dire on this.
Pardon?
I would ask to voir dire on this.
Can I have her sworn first?
Right here. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? All right, please.
Aria Griffin.
All right. And it is this court's understanding you're going to be pleading guilty to an added count 2 of assault and/or assault and battery.
Okay.
Misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th.
Yes.
You still wish to plead guilty? And to that charge, how do you plead?
Guilty.
Now you understand by pleading guilty, you'll not have a trial of any kind.
Yes.
Signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights?
No.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get to the plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
You just get the date and then I'll let counsel take over. On the date of December 1st, 2025, at the location of 114 East William Street in the city of Ann Arbor, Washtenaw County, state of Michigan. What happened that makes you think that you're guilty?
Ms. Griffin Bills, were you involved on that date, time, location in Washtenaw County with an altercation with Christopher McCone?
Yes.
And at that time, did you make physical contact with Mr. McCone?
Yes.
And that physical contact was intentional?
Yes.
Did you strike him with your hand?
Yes.
You didn't have his permission to do that?
No.
And when you did that, you knew that what you were doing in itself would be an offensive touching?
Yes.
Satisfied, Your Honor.
All right. Ma'am, I do have to advise you, between the time I accept your plea and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
I understand.
And counsel, you're not aware of any other promises, threats, or other inducements?
None, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. 15th District Court probation. Sentencing in this matter will be April 28, 2026, 9 a.m. before Judge Garwood. Bond will continue. Thank you.
Thank you very much. Take you this.
Court has called the case of versus and think he's there. He is.
Yes, Assistant Public Defender Nick Bukovich on behalf of Mr. Human.
Phelan, can you state your name for me? You're muted, sir.
Yes, my name's Daniel Heelan, Your Honor.
Thank you. You're requesting an adjournment?
Yes, it's my understanding that Mr. Human is about to finish up treatment, so we're working towards a resolution. once he has completed that treatment.
Where is he?
Bear River.
At Bear River. When are you scheduled to finish up?
I'm not sure, Your Honor. I'm waiting for a bed at a sober living house there in Ann Arbor right now. So whenever a bed comes up is when I'll be out of here, Your Honor.
Okay.
Sorry, I was about to say, in his progress report, they did note a possible discharge date around April 10th. So I would be asking for
around
that.
All right.
That way, give him time to get out and get settled.
Mr. Heelan, how's it going for you?
Going great, Your Honor. I haven't felt this good in a long time, man. I've gotten my ID back, working on getting my license. I've gotten more accomplished in the 3 months I've been here than I have in the last 3 years of my life.
That is fantastic to hear. You look better than I saw you before.
I feel better, Your Honor. I feel so much better, man.
All right. Fantastic. That's good to hear. Let's do this. Because if he goes right out, you said around the 10th, but if he goes out, gets that. I'm going to put this out to April 30th, okay? That way, if his release goes to that, he can at least get himself settled in that, and then we'll see him.
Thank you, Your Honor. That'd be perfect.
All right.
Thank you, Your Honor.
Thank you. Bond continued. You keep up the good work. You hear me?
Yes, sir. Thank you, Your Honor.
All right.
Thank you.
Court does call the case. People versus James Kierney.
Assistant Public Defender Davi Lieb on behalf of Mr. Kierney Jr., who should appear on Zoom, and there he is.
State your name.
James Kierney.
And Your Honor, Mr. Kierney is currently hospitalized. He's recovering from a gunshot wound. Would be asking for an adjournment for his recovery to move forward.
Probable cause conference. April 16th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
That can't be here. Yeah. No, you're good.
Thank you, Your Honor.
Court calls case, People versus Melvin Lilly.
Brian Bowling on behalf of Mr. Lilly, who's approaching Judge. Judge, I'm asking for an adjournment once he gets here. Take to make the record. Melvin Lilly. Your Honor, Mr. Chablowski and I had some negotiations. He wanted to reach out to his officer to get a final thumbs up on the plea offer that we're discussing. So we just need a little more time if we could.
April 16th, 2026, 9 a.m.
Thank you, Judge.
Bond continue. Thank you, sir. Oh. Hey. We have their people up.
Okay. 111.
All right. Court does call the case, People versus Jessica Puit. Let me get that one out of the way.
I'll check last.
Seriously, I can really?
Oh, this.
I apologize.
That was a setup. Set me up, Judge. Good afternoon, Your Honor. Assistant Public Defender Chinazi Carey-Akinruli on behalf of Jessica Pruitt, but not with it. Your Honor, it looks like Ms. Pruitt was released from our jail and turned over to Wayne County Jail, where she had a bond denied. We'd be asking for—
Really?
Yes, Judge.
Go ahead. I'm listening.
Be asking for an adjournment of the PCC so that we can get contact with her.
Bench warrant will issue. That way we'll make sure she comes back here. 10,000 cash surety. Warrant issue immediately. Thank you. Been a pleasure.
Have one more.
Court calls the case, People versus Christian Bird.
I'll check last.
Assistant Public Defender Davi Lieb on behalf of Ms. Berg.
What? Okay, what are we doing?
Your Honor, I'd like to set this matter for, I'd like to request a competency referral in this matter as well as address bond, please.
Forensic evaluation, you have the order?
I will submit it. I will submit it, Your Honor.
Forensic evaluation will be ordered, set a competence hearing June 25th, 2026, 9 a.m. As the bond.
Your Honor, Ms. Bird is suffering from some fairly significant mental health issues. She does indicate to me that if she were to be released from the jail, she would have a place to stay in Ann Arbor or with a longtime best friend who she indicates to me is sober. We would have no objection to a tether to ensure appearance. I have some concerns that her mental health is deteriorating while she is in custody. She does indicate to me that she would.
Do you know whether or not she can live at the address?
I have not been able to personally verify it, however, that is what she.
Well, then I need a verification before I'm going to consider that. So,
thank you, Your Honor.
Motion for bond change is denied. Thank you. What do you mean? They're going to be coming out
Yes, and I don't.
one at a time? Is that what they're doing?
Yeah. And
Okay,
I'm
well,
having
we'll stretch them into the afternoon. Tell them they can take their time if that's the way the jail's going to run. We're going. So we'll just go into the afternoon. Court's
In
gonna
this
stand in
courtroom
recess.
moment, the judge reviews a request to change the conditions of a defendant's probation. The defense explains that the defendant was already on probation in circuit court when another issue came up, and as a result, he was placed under strict monitoring, including being confined to his home. But the defense questions whether that restriction really makes sense. They argue that the defendant has been cooperating with the court and has not shown any pattern of ignoring court orders. In fact, when the judge asks an important question, whether the defendant has any failures to appear, the answer is clear. No, the defendant has shown up when required. That answer changes the tone of the hearing. From the judge's perspective, court conditions are meant to ensure that someone follows the rules and returns to court when ordered. If a defendant repeatedly misses hearings or causes problems, strict monitoring like home confinement might make sense. But in this situation, the judge points out that the defendant has been appearing as required and has not created that kind of concern. After considering the arguments, the judge decides to grant the motion. The court orders that the tether monitoring be removed, meaning the defendant will no longer be confined to his home under electronic supervision. However, the judge makes one thing very clear. This decision comes with trust and a warning. The judge tells the defendant directly that he is expected to return to court as scheduled. The message is simple. The court is willing to give him some freedom, but failing to appear after this opportunity would be a serious mistake. Moments like this show how judges balance accountability with fairness, sometimes giving defendants another chance when they have demonstrated that they can follow the rules. But it raises an interesting question. Should courts relax strict conditions like home confinement when someone has followed the rules, or should those restrictions stay in place until the case is completely finished?